If you are a green card holder, the first and most important thing to understand is that having a green card does not guarantee re-entry into the United States under all circumstances. Under U.S. immigration law, a green card proves permanent resident status, but the final authority to allow entry always rests with the U.S. Border and Immigration Officer. That officer has the legal power to allow entry, delay it, or deny it if they believe the resident has not properly maintained permanent residency. The Department of Homeland Security, commonly known as DHS, is the primary agency responsible for U.S. immigration and border security. DHS oversees multiple agencies involved in immigration enforcement. Starting in 2026, DHS has confirmed that green card holder cases will be reviewed more closely, especially for individuals who spend extended periods outside the United States or whose lifestyle does not align with maintaining U.S. permanent residency. This means that simply presenting a green card will no longer be sufficient. Immigration systems and officers now evaluate how a person is practically maintaining their permanent resident status. Whether the United States is truly considered the person's primary home has become a critical factor. U.S. immigration law includes a concept known as abandonment of permanent residency. This occurs when a green card holder's actions indicate that the United States is no longer their permanent home. This determination is not based on a single trip or one specific day. Instead, immigration authorities review the overall pattern of travel and residency behavior. If a green card holder remains outside the United States for more than 1 year without obtaining a re-entry permit, the law allows immigration officials to presume that permanent residency has been abandoned. However, beginning in 2026, enforcement will not focus only on the 1-year rule. Repeated trips lasting 5, 6, or 7 months, combined with limited physical presence in the USA, can also create serious risk. At the port of entry, officers evaluate where a person's real life is based. They may look at whether the individual has a job in the United States, whether a permanent U.S. address is maintained, whether U.S. taxes are filed regularly, and whether the family is primarily settled in the United States or abroad. All of these factors together form a complete assessment of residency intent. From 2026 onward, DHS systems are becoming more advanced and more interconnected. Travel history, entry and exit records, tax filings, and immigration data are now linked more accurately than before. As a result, any inconsistency in records can be flagged immediately at the border. Tax compliance is a critical factor for green card holders. Under U.S. law, permanent residents must file taxes as residents. Failure to file taxes or filing as a non-resident can strongly indicate that permanent residency is not being properly maintained. After 2026, such cases are expected to face increased questioning and delays during re-entry. Similarly, misuse of government benefits or providing incomplete or incorrect information to authorities can also create serious problems during re-entry. Border officers have the authority to refer a green card holder to secondary inspection, where more detailed questioning and document review takes place. Being sent to secondary inspection does not automatically mean deportation. It means the officer has concerns about residency status. The process can take time, and in some cases, a decision is not made on the same day. Some individuals may be granted temporary parole, while others may be ordered to return abroad. Another important point is that DHS usually does not provide advance warnings. There is often no letter, email, or notice informing a person that they are at risk. Many green card holders only discover there is a problem when they attempt to return to the United States after traveling. For this reason, awareness and planning are essential. Starting in 2026, the safest approach for green card holders is to actively maintain residency. This includes spending substantial physical time in the United States, maintaining employment or business ties, keeping a permanent U.S. address, and ensuring tax filings are accurate and consistent. When extended travel is unavoidable, obtaining a re-entry permit becomes extremely important. A re-entry permit demonstrates that the individual informed the U.S. government in advance of temporary travel abroad and did not intend to abandon permanent residency. In many cases, this permit provides strong protection during border inspection.